Good evening. Welcome in to the evening edition of From Day One. We'll pick it up right where we left off with the idiot in court.
You know that you could face up to 93 days in jail and over $7,500 fine. You understand it.
Up to that. Okay, but I don't even understand what the charges are.
Okay. And do you have any questions for me about any of the rights that I listed, that you have to have an attorney and have a hearing and present evidence? Do you have any question about any of those rights?
I have a whole question about the whole context of everything today, Judge Gauthier.
It's really quite simple. When you have an order to show up for court and you turn in a cut up piece of paper of it to say you're refusing to attend, that this is what happens next. That's pretty simple.
Oh, did that offend you?
No, it did not offend me. It was a contempt of court.
It's a common law
It's not about
thing.
anybody's personal feelings. It's about the authority of the court to compel appearances. You did not appear. So I do believe, based upon your answers, that you do understand the maximum penalties that you face and the rights that you have. So, Ms. Bridgman, Mr. Villanueva indicated that you wish to plead not guilty to those charges of contempt. I gather from your comments that you would agree that you're not pleading guilty.
Correct.
That's correct. Okay. All right, so we'll enter a not guilty plea on your behalf to both contempt citations. We'll schedule this for a hearing where the prosecutor will present evidence, and you can present evidence in your defense. If you want to have an officer come testify on your behalf, you can certainly do so.
I would like to request a trial by jury.
There is no right to trial by jury in a contempt matter. So
Oh.
that request would be denied.
Okay, so then there's no chance to understand what you're charging me with prior to this hearing.
I've told you what you charged. I can read it again if you want.
I don't see where there's a code or a statute or any law that I have actually violated here.
Well, that's not required to be on a contempt citation. I've told you what the allegations are. If you want me to read them to you again, I will.
Okay, and the contempt charges that you're saying have changed from the first time.
No, there are two. One is the contempt for unauthorized practice of law and preventing Mr. Flores from meeting with his MIDC attorney prior to his arraignment. The second one is for failing to appear for the show cause hearing on that contempt.
So I only show one now.
What is
Okay.
the one you have?
And this is preventing, and how did you arrive at this at a later date than to issue a bench warrant?
Mr. Villanueva?
There's two items check marked here.
This is after the fact, so then you added a different charge than the previous one about the same date.
Ma'am, he read two charges. There's two charges marked here.
Excuse me. I probably have more degrees than you do,
All right.
okay?
All right.
Now,
I'm going to find that,
what please, Judge Gauthier,
sure, go ahead.
thank you. Okay. So the first one was that I was practicing law. That was the first one. That's the show cause that you say I failed to appear for.
No, it was contempt for unauthorized practice of law and preventing defendant Flores from meeting with MIDC attorney prior to his arraignment. That was on the original.
No, I have a picture of the original one. This is why I'm not sure.
Do you have a copy of that show cause in front of you right now or no?
This one.
Would you like to see what she has
But-
here?
I just. so if
Okay,
you don't-
so how do I
Hang on,
defend?
hang on. If you do not have in front of you right now a copy of the first show cause, I'm happy to provide a copy to you.
So how did you arrive at a second show cause?
Because you didn't show up. The second show cause is for failing to show.
But I wasn't on bond. So both show causes are not in effect because I'm not on bond.
Your Honor, what is the date of the first show cause?
December 20th.
No, the December.
Oh, sorry, that was before the December 20th.
All right. You may view this document. This is out of the court file. You may view it and then.
So-
send it back.
Judge Gauthier, do I have any other recourse to clarify where I was on that day and the information that I was going off of by your own investigator?
You do. You do. And
Okay,
that is a hearing date. Today, we're going to schedule a hearing date and you can present that evidence at that time.
and how will the hearing affect a trial by jury?
as I told you, there is no right to trial by jury.
For a
in
contempt charge.
So I
Oh,
can
so
schedule
this is a perfect, nice little tidy package for everything. I see. Okay,
So I can schedule this for a contempt hearing on Thursday, January 11th at 2 p.m.
I think that would be way too soon for me. Thank you.
Why is that?
I need to get to some of the documentation and follow up with that, state trooper, as well as perhaps a few other people, because I'm guessing, am I supposed to just talk to the prosecutor without the other witnesses that I had in my presence at the same time?
I could schedule this for the afternoon of Thursday, January 25th, then, gives you 3 weeks.
Thank you.
So we'll schedule this for a contempt hearing on both allegations of contempt on Thursday, January 25th at 2 p.m. And do I understand correctly, you do not wish me to appoint an attorney that you want to represent yourself?
And then who makes the decision? You make the total decision then?
Well, no, first you make the decision whether you want to represent yourself. As long
No.
as I'm convinced that you're doing so of your own free
Okay.
choice, that you understand what's going on and that you're not going to be unduly disruptive, then you'll represent yourself.
So what am I allowed to do at the hearing to defend myself appropriately?
You're allowed to present legal arguments. You're allowed to present witnesses to testify under oath,
Okay.
yourself or any other witnesses that you bring with you. If you want to subpoena a witness, if you're representing yourself, you can't issue a subpoena without the court's signature. An attorney can issue a subpoena on their own.
So
If
I
you want
can't
to
subpoena
subpoena
them.
somebody, what you would do is you go to the court clerk, they give you the paperwork, you'd fill out the subpoena. They would give it to me to review. And if it looks like it's reasonably, connected or relevant to the case, I would sign the subpoena. And it would be given back to you for you to serve upon the person to compel their appearance.
I did not even get to watch the video that day because I was still on the phone with the trooper. And then people told me after I went up for Christmas that there was maybe a bench warrant, that you had issued a bench warrant, but everybody looked for it online at VineLink and couldn't find any bench warrant. So I was not trying to, I thought that trooper had told you what she told me, that I wasn't on bond, so I couldn't have a show cause.
Okay, well, that's all going to be sorted out at the hearing. Okay, we don't have to sort all that out today.
Well, that's a lot of overnight in being arrested downtown and everything for a misunderstanding that I would like to,
Mr. Richmond, I mean,
okay, I get it,
You're not
Judge Gothier, I know what happened,
You're
but
not fooling me. I've got the show cause that you apparently cut up into little strips and wrote.
yeah, but I brought it at 9 o'clock because do you know that that's actually a common law practice? And there are courts that recognize common law because sovereign people and people who take an oath of office can follow common law.
All right, so the
Not the
contempt hearing
codes
on
and
both
statutes.
matters is scheduled for Thursday, January 25th at 2 p.m. I find that Ms. Bridgman is unequivocally exercising her right to represent herself, that she understands the nature of the charges against her, the maximum penalty, and the rights that she has. I find that although she certainly disagrees with the court procedures and processes, which is her right, that she's not being unduly disruptive to the court's business. So the court's going to recognize Ms. Bridgman's right to represent herself at that hearing.
Can I ask one question? What are the parameters that you're going to decide is practicing law versus helping somebody maintain their unalienable rights? How would I delineate that in defense of myself?
Well, that's a question of, excuse me, that's a question of law that you can research before that day. And I said, I'll entertain legal arguments. The prosecutor will have to prove beyond a reasonable doubt at that hearing that you did in fact practice law on that day. That's where then there's a risk to representing yourself, because an attorney, has access to and better training and researching the case law, interpreting what that is. The Michigan Supreme Court has issued some opinions about what that is. If you're representing yourself, you're going to have to find those on your own and make the argument as you see fit. If you want to hire an attorney, or if you want an appointed attorney, they would be able to fashion those arguments on your behalf. But I'm not gonna,
No, I've been
Tell
down
me
that
what
path
the rules
before, and it never turns out the way they first present themselves to you, that they're gonna fight the case. It never turns out that way. So I'm fully cognizant and aware of that, but I wanted to see what your standard was going to be.
it's going to be what the law requires.
But I'm not sure which law you're referring to. So I have to research all the laws to determine what this says that is different than the first show cause.
Yep, Ms. Bridgman, if you want to represent yourself, it's a little bit more work. You're gonna have to-
I'm not saying it's not more work. It's also not presented in a way that tells me what I'm really being charged with. Or that anybody has any proof of what they said here. So that's what okay.
All right, well, that's what we'll.
All right,
sort out those
thank
legal
you.
Arguments and the prosecutor will present witnesses at that hearing and you can present witnesses. As I said, if you desire the court's help in compelling the appearance of any witness on your behalf,
Okay.
submit a subpoena to the clerk's office that I
Right.
would review. It'd be the district court office
Okay,
that I would review and I would issue the subpoena. If it's-
so one of the key laws would be that in the state of Michigan, anybody practicing law should have, be a member of the Bar Association, am I correct?
That is correct.
Now,
Ma'am, you have to figure that out at another time, okay? Now's not time to litigate this case.
Yeah, so I have a range
I
of other
get it,
charges to
but
set.
I
Right.
appreciate that this is very big in scope and Michigan statutes and codes, as he says, he's compelled to follow or must obey the dictates. Okay, I'm very well versed in enough constitutional things, so I have to know what the perception is there. So, thank you, I appreciate
And Ms.
any
Bridgman,
clarification.
I do have to follow with the, any decisions of the Michigan Supreme Court are binding law on the lower courts. There are constitutional system in Michigan. Also, any statutes that were passed by the legislature and signed by the governor are laws that this court and all citizens of the state of Michigan have to follow.
So the procedure that was followed here, I could still take up in another manner, correct?
I'm not sure what you mean by another manner. At the hearing, you can challenge the procedure of it.
I was talking to your investigator. She knew what time I had a court date.
Yes, absolutely. If you want to present that person to come testify about that.
Oh, she's not gonna come testify, I'm sure. She's downstate. She might write something.
Well, that's up to you, what you want to present. If you're going to
Okay.
represent yourself, you have to decide how you want to present your case. But I'm giving you the extra time you've asked for.
So this is a major judicial review. Okay, to decide if anything in our Bill of Rights actually applies to the Michigan code and statutes.
You have all the rights in the Bill of Rights. I recognize all those constitutional rights. of course.
And most of what I talk about actually falls under common law because it's common that anyone could understand it.
All right. so
That's
this
why it's
is-
called
you
common.
Set the hearing date.
Okay.
We'll arrange you on the charges. I'm going to recognize that you are exercising your right to represent yourself and discharge Mr. Villanueva from any further responsibility in the matter. The only other question I have to decide is whether you should be released on your own recognizance, or whether you should be required to post a bond before the next hearing. So I'm going to hear first from the prosecutor and then from you on that question. Ms. Miller?
Your Honor, I would object to a PR bond in this case first because of her failure to appear on December 20th. She had notice of that hearing date as she dropped off the show cause to the court that had the date on it. Further, an underlying case that this was initially filed, she encouraged someone to not appear for their court date or to leave the court before they were arraigned. So I do have a concern about her appearance at the next trial, the next date.
All right, Ms. Bridgman, anything you want to tell me with regard to whether I should allow you to be released on your own recognizance before that hearing, or whether
I showed up at 9 a.m., Your Honor, and anybody could have called me if they didn't understand that. I filed a similar document in Mackinac County and they accepted it. Common law is a very acceptable kind of a standard if you know it and you know what you're doing. So maybe there'll be a chance that I can present some of these other avenues because how does my country tell me to take an oath of office to defend the Constitution, but then I'm held to only codes and statutes of the Michigan legislative body, governor, and perhaps Supreme Court? That's the overarching question here, I think. And I think a lot of people
Well, I can
struggle with
recommend the
that.
Schoolhouse Rock video to you about how a bill becomes law and the laws.
Oh, I know how it happens.
Your Honor.
I also know we don't have a lot of
Your Honor.
judicial review.
So,
Your Honor,
as
part
the
of the-
bond question, any input, Mr. Gilroy?
Yes, I guess, I know you just released me as,
Oh my
as
God,
the
Your Honor, I
attorney
love
of
that.
record, but I guess in support of the bond on her behalf, would.
Yes, go ahead.
Yeah, so I like to advise the court that Ms. Bridgman is a resident of the city of Sheboygan. She advised that she's a former social studies teacher. She's presently collecting disability. So she informs me, I'm unaware of the status of if she has an automobile or anything. I'm not aware of any known criminal history for Ms. Bridgman, and she reports that she has no drug or alcohol issues. Granted, there's this allegation of not appearing at a previous hearing, and she was picked up, I believe, within the Sheboygan County for that. And so I advise that Your Honor. Oh, and one last thing, she's a politically active member in the community. She has audited an election previously, so I believe she's more or less, I guess, committed to this area, this local municipality. It seems unlikely that she would go anywhere, and how she would do that. And so, Your Honor, I would ask that you set reasonable bond for her release.
Thank you.
All right, thank you. Well, I don't believe that Ms. Bridgman poses any danger to public safety. I don't think she's a flight risk per se of fleeing from the jurisdiction. However, I do believe that she's a heightened risk of just flat out refusing to appear, as evidenced by the fact that she cut up the previous show cause into little strips and wrote that she wasn't accepting an offer.
Well, they
It wasn't
didn't,
an offer, it was an order
sorry,
to appear.
They didn't
And you can't
actually
have
hand it
people
to me.
just refuse to appear on orders to appear by saying, sorry, I don't want to. So I don't think that release on her own recognizance would be sufficient to secure her appearance. So I'm going to set bond in the contempt matter at $10,000 cash or surety in the full amount. There'll be no special conditions attached to it, however, just the standard conditions, Ms. Bridgman, that you have to make sure that we know. If you change we have to know your address, contact information. You can't violate any laws in the state of Michigan or any political subdivision thereof, and you must appear for all court appearances.
so the whole bond thing keeps me under your jurisdiction, which I wouldn't have come into your court the same way today, except that you put me in jail, so I was forced to.
That's the bond that I've set. So
This is the struggle between keeping my oath to defend the Constitution and adhering.
I've taken a similar oath, and I believe I'm going to today, Ms. Bridgman. So we'll see you on the 25th.
We will look at the case law.
That's what. All right, we'll adjourn.
Alrighty, I believe that's all we have of her, but just give me a few seconds while I check to make sure. All right, so with that, we'll do this one final fight and then bring the day to a close here on From Day One. As always, please make sure you do like, share, and subscribe. Be kind to one another and release the Krakens. And actually, it looks like we won't be doing this fight because we're out of the potions for now. So until then, tomorrow, have a great day and thank you for watching From Day One.